Am I invited?
Meet everybody. Speakers pouch.
Hello, Toluwati, we're on it. Hello, at February, right? Tolu, I'm in a meeting, please. Yes, good afternoon, everybody. We are sorry starting this meeting behind schedule. Yes, my name is Femi Onepede, and you are welcome to Ministry of Justice Academy. And we are having a presentation this afternoon, and then we want to share our experience in litigating Garnishee matters. So without wasting much of our time, I would like to let us know that we are broadcasting live from the Ministry of Justice Academy. And our resource person is the Director of Civil Litigation, Ekiti State Ministry of Justice, Mr. SBJ Bamishe. Mr. SBJ Bamishe is the Director of the Department of Civil Litigation in Ekiti State. And then by virtue of being in that department, he has done a human's job by making the litigation in Garnishee Proceedings worth the while. So without wasting our time, I would like to invite Mr. Bamishe to have his presentation on Ministry of Justice experience in litigating Garnishee matters. Mr. Bamishe, let us have you.
Somebody should go downstairs and call him to come and present on this one. You had all this while to present this thing. You didn't test, you didn't do anything. This is shortly preparation.
Now we now have a resource person here with us in the studio. And like I said, he's a big fish that needs no introduction, but as a matter of fact, we have to introduce him. Mr. Bamishe, Director of Civil Litigation, the State Ministry of Justice, you now have the floor. Tell us your experience, the Ministry of Justice experience in the Department of Civil Litigation, and particularly the matter of Garnishee matters.
Yes, thank you. Let me first of all welcome all participants to this platform. The topic for this webinar is litigating Garnishee matters, the State Ministry of Justice experience. As you are aware that Garnishee issue is something that is very important, especially when it comes to enforcing judgment in the law court. It is important for us to, first of all, understand what is actually Garnishee Proceedings, which we all are aware as one of the methods of enforcing judgment, especially by a judgment debtor, creditor, where the money of a judgment debtor is kept with a third party, especially the Garnishee, the banks. We should understand that there are conditions precedent before a judgment creditor can approach the court to enforce judgment debt. One of these conditions are that there must be a subsisting monetary judgment handed down by a competent court of jurisdiction. It is basically upon that judgment that the judgment creditor will approach the court. Then the judgment debts must have remained unpaid. That's the second condition. And again, the third condition is that the money sought to be attached must belong to the judgment debtor. The money sought to be attached must belong to the judgment debtor. It mustn't belong to a third party, because if a third party has a lien on the money that is sought to be attached, then the judgment creditor will have the opportunity of setting aside whatever order, especially order nicer, obtained by the judgment creditor. What are the procedures? You understand that, like we are aware, that the first thing the judgment creditor will do is to approach the court via an ex parte application, accompanying with an affidavit, evidencing the fact that there is a subsisting judgment and the facts relating to the fact that the judgment has remained unpaid by the judgment creditor. That is the first stage, because we should note that there are two stages in Garnishee proceedings. The first stage is to approach the court with motion ex parte. After obtaining motion ex parte by the judgment creditor, the judgment creditor is obliged to serve upon the judgment creditor that order nicer within 14 days before the hearing date. This is very, very important, and this is provided in Section 3.2 of the Sheriff's and Civil Process Act. The judgment creditor ought to be very careful, because if he doesn't serve the judgment debtor within 14 days before the hearing of the matter, then that organizer will be a nullity. We should bear in mind that after service of this organizer on the judgment creditor or judgment debtor, the judgment debtor under the law now has the right to be heard. Like I said, there are two stages to the proceedings. At the first stage, the judgment debtor doesn't have the right because the judgment creditor will have come by via application, the ex parte application, which means it will not be heard. But immediately the organizer obtained via ex parte application is served on the judgment creditor, debtor, he now has the right to oppose the court to be heard. And you have to be aware that in Garnishee proceedings, the judgment creditor will have to sample different banks to ensure that he's able to get or recover his judgment debt. In practice, he might decide to sample almost 15 or 20 banks and join them in the proceedings before the court. These banks are called garnishees. And he is also expected, that is the judgment creditor, to serve all these banks, the garnishees. The essence of serving them, the organizer, is for them to come and show courts why the organizer will not be made absolute in the next adjourned date. So the banks are obliged to come to court on the next adjourned date with affidavit to show cause and file same in the court registry, disclosing whether they have sufficient funds to satisfy the judgment debt. Like we said, we are aware that the banks are third party to these proceedings. But sometimes some people, some of our colleagues feel that the proceedings is just between the judgment creditor and the banks, and that there's nothing concerned the judgment debtor. This is not so, because as we are aware that the judgment debtor is to be served the organizer before 14 days, like I said. Statutorily, we are the judgment debtor is already the party to the proceedings. In that case, the Sheriffs and Civil Process Act has made the judgment debtor a party to a Garnishee proceedings. There are a lot of, plethora of authorities which has now specifically made the judgment debtor a party to Garnishee proceedings.
Yeah, I just a view. I'm not.
There are situations where, like I said, there are situations where the judgment debtor now has the right. In some situations, the judgment debt. From experience, in 2018, we had a situation where we had to oppose the court. To the tune of about 3.6 billion. The genesis of that matter, which is Olubumo versus government of the state, was that upon the dissolution of the local government, by the government of the state, The concerned 16 local government chairmen approached the court to ask the court to nullify that dissolution. All through from the High Court to the Court of Appeal to the Supreme Court, we discovered that there was nowhere they asked for specific sum. So throughout their case up to the Supreme Court, they did not actually ask for any specific amount of money. But at the Supreme Court felt that since they could not be returned to their offices, because at that time, their tenure had already expired, the Supreme Court made a consequential order that all the allowances be paid. Unfortunately for them, they engaged an independent auditor to help them compute their allowances for about 12 months without carrying the government of the states along. They came up with a bogus sum of 3.6 billion. And eventually they got another nicer upon it. We approached the court as judgment debtor, and we asked the court to set aside that order based on the fact that the money sought to be attached, upon which the court has granted an order nicer, is uncertain and bogus. And the court listened to us, and that order nicer was set aside. We are aware too that the judgment debtor can also approach the court for such an order to be set aside if there is an appeal already against the judgment being sought to be attached. You are aware that an appeal does not actually operate as a stay. There must be accompanied with that notice of appeal a stay of execution. So if there is a stay of execution with that notice of appeal, the judgment creditor cannot proceed, or the Garnishee proceeding cannot continue. Now, there are some issues that need to be discussed, which has to do with the consent of the Attorney General in Garnishee proceedings. This is a very, very contentious issue. You are aware that under Section 84(1) of the Sheriffs and Civil Process Act, if money liable to be attached is under the control or custody of a public officer, that is public office of a state or that of the Federation, there is need to obtain the consent of the Attorney General before a judgment creditor can obtain an order nicer attaching the fund of a state government. Now, the question has arisen as to the fact that who is actually a public officer in this respect. Because it's discovered that in the Supreme Court case of CBN against the Interstellar, the Supreme Court has held that commercial banks or private banks are not public officers. And as such, Section 84 of the Sheriffs and Civil Process Act will not be applicable. In this respect, unless money kept by the state government is with the central bank, or peradventure the money is being kept by the Accountant General, possibly in his vault, which is impossible anyway, Section 84 of the Sheriffs of Civil Process Act, will not apply. Because we discovered that there is no way government will keep money in a private room or in a vault in a government office. And as such, all government funds are kept with private banks or commercial banks. And unfortunately, In as at 2004, in purification techniques against Attorney General of Lagos State, this issue also arose as to the fact that the monies kept by Lagos State government, which were deposited in commercial banks or private banks, are actually public funds, and that it was Attorney General of the state that had control and custody of such money. Well, they got judgment at the lower court, but at the Court of Appeal, Lagos, the Court of Appeal held that monies kept in commercial banks or private banks, though they might be public money, but the Accountant General of the state does not actually have custody or control of those money. This principle of law actually stems from the English case of Joachimson against Swiss Bank. As we are aware, in that case it was held that neither the customer of a bank has control or custody of money kept in banks, that the only right such a customer has is contractual right for him to demand for his money at any particular time. So this is a very contentious issue, and I'm aware right now that some lawyers have been pushing the National Assembly to actually amend Section 84 of the Sheriff and Civil Process Act, because they feel that it is would be unconscionable for them to approach the Attorney General, who is also a debtor, for them to grant them consent before they can actually recover their judgment debt. But I want to believe that before the National Assembly can pass this kind of law, this bill into law, there is need for the National Assembly to ensure that there is public hearing, so that all the Attorney General of the Federation, 36 states, can have the opportunity to also hear their view as regard the fact that their consent is needed before monies kept under their control or the control of the Accountant General is actually attached to satisfy judgment debt. The reason, but the purpose of that Section 84 really is that to ensure that the state is not actually embarrassed if money meant for a particular project is diverted by way of actually paying judgment debt. Now, like I said, issues like this are very, very paramount. The Supreme Court in a recent case of Wande versus Attorney General of Delta State has actually settled another contentious issue regarding whether a judgment creditor or judgment debtor is a party to a Garnishee proceeding. Because some of our colleagues, especially those practicing outside, don't still believe that the judgment debtor is a party to the Garnishee proceeding. And this issue has remained contentious. And you discover that if the judgment debtor filed an application to set aside another NISA that was obtained without jurisdiction, the question they always put up is that this proceeding is between the judgment creditor and the judgment and Garnishee. and that the judgment debtor is not a party. But like I said, in 2019, in Gualden against AG Delta State, this position has been settled by the Supreme Court to the fact that a judgment debtor is a proper party in a garnishee proceeding. Before then, the Court of Appeal, Benin, Pa Ogunwuiju, in the Nigerian breweries against Dumije, has come up with an extensive principles regarding this issue we are talking about, to actually lay down the fact that a judgment debtor is a proper party to a garnishee proceeding. Now, we need also to determine which money can be attached in a garnishee proceeding. Because, like I said, if there is a lien on a money that is that is kept with a bank, the judgment creditor cannot attach such money because such money belongs to a third party. In that respect, such money cannot be attached in a garnishee proceeding. Then, after, the only money that can be attached is money that is in bank before the orderizer is granted. So money subsequently paid in after orderizer has been granted cannot be attached, because we see a situation where after monies are paid, after the orderizer be obtained by the judgment creditor, money subsequently paid into that account to be attached by the judgment creditor. It is not so. The law does not allow such a situation. Yes, we also have to note that the judgment creditor has a lot to do to ensure that he's able to recover his money, because it's not expected that he lose the fruit. I mean, he failed to actually benefit from the fruit of the judgment already obtained. So he has to be very, very smart, because once he makes a mistake, he might lose his money. Because once he files necessary application to attach the judgment, and that application is dismissed, he cannot come back again to file another application or begin again the same process, because that will amount to an abuse of court process. And we should also know that in garnishee proceeding, once another absolute is made against the judgment debtor, that order can only be appealed against. It becomes a final judgment, and as such can only be appealed against. And you should also know that another NISA cannot be appealed against. It can only be set aside by one way or the other. So he has to be very careful when he is preparing to approach the court, to ensure that he benefits the fruit of his judgment. We like to also note the fact that some of the cases that we have approached the court to help the state set aside some of the orderizer obtained against them borders on the fact that these other NISAs were not actually the sum, the sum upon which the other NISAs were obtained were bogus. And that was why I was saying that it is necessary that whenever the judgment that creditor wants to approach the court, it is necessary that he should also approach the Attorney General to seek for his consent. Otherwise, it won't go well if eventually the other NISA is made absolute and the money upon which this order is made is bogus or is uncertain. Though, like I said, the judgment debtor has the right to approach the court to also set this other NISA aside if it is bogus. In this respect, I would like to allow participants to ask questions if because I believe that this is a very contextual issue. We can all of us can actually contribute so that eventually we also benefit from the discussion.
Yes.
Thank you.
Yes, before our participants start to ask the question, we want to appreciate you for this lecture conversation you just had with us. Sir, you'll be saying organize high or the one absolutes, and also you say Garnishee, Garnishee. All this nomenclature, please. When, or let me put it this differently, who is a Garnishee? Some people will say Garnishee is the bank, some Garnishee is the judgment creditor, the government debtor. Who is a Garnishee? Who is a Garnishee? Please, can we please help us clear the
yes, the nomenclature at times can be confusing, but we must note that the judgment creditor is the Garnishee, while the bank is the Garnishee. So the judgment debtor is always the judgment debtor. But at times it could be confusing because but it's better for you to just use the normal words, the judgment debtor and judgment creditor and Garnishee.
Okay. Yes. I'm clear that there are steps to take while you want to enforce this. When you're bringing an application for Garnishee proceedings, and I'm sure the law must have stated the conditions that the Garnishee will put in his affidavit. Does it include the judgment itself and then the particulars of the case and what have you? Because the matter is so that the judgment creditor will not say that because the application is motion ex parte, that even if those things that are required to be put into the affidavit and support, if they are not there, the court will still grant it. Is there a condition or situation whereby on the strength of your application as a judgment creditor fail when you apply for the order of Garnishee proceedings?
Yes, like I said, I've actually said that the judgment creditor has to be very smart, because once he makes mistake, the mistake will be fatal. And as such, when approaching the court, the first thing, like I said, is he has to file an application, motion ex parte. That motion ex parte, he has to accompany same with an affidavit showing that there is a subsisting monetary judgment, handed down by a court of competent jurisdiction. And he must show that that money has remained unpaid. So he must be able to convince the court that the judgment debtor is actually indebted to him before the court can go ahead to make another NISA. The court is aware that at that stage, like we said, the judgment debtor is not a party. the judgment debtor will not be there, because even if it is there, I mean, it could not be here because the application is brought ex parte. So it is the responsibility of the judgment debtor, the counsel to the judgment creditor, to convince the court via his application, supported by cogent, deposition in his affidavit, convincing the court that there is a subsisting judgment and that the judgment debtor has actually failed to satisfy that judgment after several demands, especially if accompanying the letters of demand, the judgment itself, we attach accessibility to that application before the court can grant ordinance.
Okay, thank you, Mr. Bamishe. Our audience, I would like to appreciate Mr. Bamishe for this erudite presentation. So there's this question that has been bothering our colleagues' mind, that when you institute a matter in a state, you can, if the properties to be attached is another state, you can go to other states, register the judgment, and then you enforce the judgment as if the welcoming state, you welcome the judgment and then execute it as if it is the judgment that was delivered by them. Can this same principle be applied in Garnishee proceedings? And then if it is so, how?
Yes, the law is settled that when it concerns the issue of jurisdiction, you can enforce a monetary judgment at any court, even including the magistrate court. So a judge, you can obtain judgment at any state and go to Lagos and enforce it. Like I said in Olubumo case, the matter went up to the Supreme Court, and you are aware that all facts relating to that case actually transpire in Ekiti State in respect of the distribution of local government. When the judgment creditor wanted to enforce the judgment, they approached the Federal High Court, Lagos. Our concern then was that why the Federal High Court, Lagos? We were thinking of actually challenging the division of the Federal High Court, Lagos. And well, we are aware that Federal High Court has relation. It's just a matter of administration. There's the Federal High Court in the state. So we're thinking that why the Federal High Court, Lagos? But the law is settled as, like I said, the judgment creditor can approach any court to enforce judgment debt, so far the sum is certain. Unless if the sum is not certain, it's bogus, then the judgment debtor, like I said, have the right to approach the court to set aside such a judgment.
Yes, there's this question bothering the mind of our colleagues, that this aspect of the law that says Attorney General's consent is needed for a monetary judgment to be executed against government or its MDAs. Now, don't you think it is a clog to the Garnishee reaping the fruit of his judgment? Because when a judgment is given, the next thing is execution. What do you feel with this provision of the law that says, let the Attorney General be informed, and then what of if he declines? Yes.
Yes, I also share your view as regards the fact that the Attorney General is also a debtor somehow, especially where the judgment is being enforced against the states. But to some extent, that provision, Section 84 of the Sheriffs and Civil Process Act, is apt in the sense that the import of that provision is to ensure that the state is not embarrassed where a judgment creditor just approached the court with a bogus sum of money somehow, and without actually passing through or seeking the consent of the Attorney General. And somehow another NISA is obtained, and peradventure, the order is made absolute. What happens if such a judgment creditor has first approached the Attorney General's consent, approached the Attorney General for his consent? At that stage, it's possible for both of them, the judgment creditor and the Attorney General, to discover that this sum that you are trying to enforce is not the exact sum that the state is owing. It is possible to resolve that issue at that stage. It is also important to inform the audience that we have to give kudos to the Attorney General of Ekiti State, Mr. Olawale Fakunda. When he came on board, there is one thing that he did. He ensured that all the judgment debts that the state is owing, he ensured that all of them are aggregated. And there is a specific data actually showing the amount. He also tried to ensure that he invited all the judgment creditor into a meeting to ascertain the veracity of this judgment debt. At that stage, you know, this kind of approach has actually helped us in Ekiti State, because at that stage, there are some of the judgment that we have to reschedule and even negotiate, and even to the benefit of the judgment creditor. And to some extent, we had to enter into terms of settlement where we agreed to be paying on installments, and some of them are now being paid by the state. So it is very important that a judgment creditor approach the Attorney General for his consent, because instead of because they will also spend money in approaching the court. At that stage, the Attorney General can as well go into terms for the settlement of such judgment debts.
Yeah, thank you, the Director of Civil Litigation, Ekiti State, Mr. SBJ Bamishe. Yes, we will have one of our participants here. We have our Rivad Oga, the former Attorney General of Ekiti State. Also, the member of Board of Trustees. We have our own Obafemi Adewale. So, Mr. Obafemi Adewale, we would like to have you add your voice to this conversation. So we want to have you.
Thank you very much, Femi. I want to thank the Honorable Attorney General and the Ministry of Justice for organizing this webinar. And I want to commend the Director of Civil Litigation for his erudite presentation. Of course, I'm not surprised. He has the experience and he has the capacity. I have learned a lot from listening to him, because one of the reasons why I decided to look in was because I needed to know the thinking of the Ministry of Justice on this issue. And I must say that I've been educated, and I believe that with the position taken in his paper, it should be easier for the ministry and government to reach accommodation with judgment debtors instead of parties engaging in endless litigation. I think this is a very good initiative to enlighten us on both sides on the issue of Garnishee Proceedings. And I have no doubt whatsoever that our colleagues will also learn from this. Thank you very much. And thank you, Mr. Wale Faponda, the Honorable Attorney General, for organizing this. I can cite the Solicitor General. I'm happy to be here, and I send warm regards to all of you.
Thank you, sir.
Thank you.
Thank you, sir.
Yes, I would like to hear the view of the Director, Corporate and Commercial Law, Ministry of Justice, Mr. Agbemiga Daramola. What are the unsaid things regarding Garnishee Proceedings? Mr. Daramola? Mr. Daramola, can we have you? Okay. While we are still expecting Mr. Daramola to join us, we have our people that have joined us. We have the Solicitor General, Secretary, LB Ojo. So we have the Director.
I have
yes, Mr. Daramola, we have you here.
Network issue. Mr. Anipede.
Hello,
Mr. Anipede.
You have the line. You have the line.
Mr. Anipede, I'm very sorry. I have a network issue. What is the question?
The question is.
I just want to get your question very well. I have a network issue when you.
Okay.
Yes.
While you are taking care of the network issue, let me do some kind of. Let me recognize some people that are put their name on the.
Let me know what you want me to say. Let me know what you want me to say.
Okay. Yeah. The question that I ask you is this: you've had the presentation. I now ask you that with all these conversations we have, what are the unsaid things that you know with regards to Garnishee Proceedings that you feel that can add to this presentation?
Thank you. First of all, I just want to appreciate the Honorable Attorney General for organizing this program and all the participants. Equally, the panelists, that is the person who presented this program, Mr. Bamishe, I appreciate him also. But one important thing that I want to say is this. While it is incumbent on the judgment creditor to inform the Honorable Attorney General of either the state or the Attorney General of the Federation that he wants to enforce his judgment or he wants to garnish the account of the judgment debtor, it is not compulsory that the Honorable Attorney General should respond or decline. The only provisions of the law is that you inform the Attorney General. If the Attorney General responds, good. But if he fails to respond, the judgment creditor can go ahead and file the Garnishee proceedings. So the judgment creditor cannot wait in eternity for the Honorable Attorney General to respond to that presentation. Thank you.
Yes, Mr. Bamishe, we appreciate you for this conversation we're having with us. You've shared with us your experience in litigating Garnishee matters in the Ministry of Justice. And I want to appreciate the Attorney General and Commissioner for Justice in Ekiti State, the #1 law officer, Madam refused to be called chief, though the law has put chief constitutional to his name. Yeah, I want to appreciate the members of of the committee, the Ministry of Justice, Governing Board that put this together. And I want to let us know that this thing, the presentation is a series that the Ministry of Justice Academy will be presenting. By next edition, you will know what we are going to bring forth for all of us to engage in. And also, I want to appreciate people that participated in this conversation. I want to appreciate Mr. Clement Ayola, Mr. Adekeye G. Adegoroye. We want to appreciate Magistrate Adefunke Anoma, Oludayo Olorunfemi, the Vice Chair, Nigerian Bar Association with the States, Alhaji Jare Abigail. Yes, our landed Oba, we recognize you. Mr. A.A. Murakeyo, we appreciate you. And yes, our Executive Secretary, Mrs. Bolawale, where we appreciate you for attending this conversation with us. Yes, I would like to hand over the platform to Mr. Garnishee to give us the summary of the lecture and the conclusion, so to say.
Yes, thank you, Mr. David. I want to quickly respond to the comments of my learned colleagues that are mother, that respond to the fact that the judgment creditor doesn't have to wait for the consent of the Attorney General before approaching the court to enforce his judgments.
We should read critically section 84, 1 of the Sheriff and Civil Process Act. What that section is saying is that the consent of the Attorney General must first sought and obtained. That's the language of the law. So it is paramount. They ordinarily Interstellar, CBN, Central Bank of Nigeria against Interstellar. It was held in that, the Supreme Court held in that case that, well, they are not expecting the Attorney General to hold their consent because they expect that the Attorney General will use his offices as the chief law of the state to ensure that a judgment creditor actually reap the fruit of his judgment. But we have to stress the fact that the judgment creditor cannot just oppose the court after notifying the Attorney General if eventually the Attorney General doesn't respond and go ahead with the proceedings. The proceeding can be set aside. To that extent, I equally want to thank the Honorable Attorney General for this opportunity. It's a very good approach, and we are looking forward to continue with this presentation so that within us, even the ministry, we can gain a lot. There are a lot of things that we actually gained today, especially as regards the fact that money kept in commercial banks, that we don't have control over them because the Supreme Court has said that except where the money is kept at central bank, it is when we say that, okay, the public officer has control or custody of such money. So that is something to take home, because before we used to believe that Attorney General has control or custody of all the monies that the state government has with commercial banks. Those banks are private banks, and they are not actually public officers. And Section 84 of the Sheriff and Civil Process Act will not be applicable in respect of such situation. In that respect, I want to thank everybody, especially participants who have actually listened to this presentation, and we look forward to others. Thank you.
Yes, on the final note, like I would like to say that I don't want to bother us with or bore us with speech making. Let us be reminded that this presentation is part of the State Council lecture series. They are under the umbrella of Ministry of Justice Academy, and this thing is going to be on weekly and fortnight basis. So until the next time that we will bring the next presenter who will give us another thought-provoking topic. Have a beautiful weekend. Thank you.
Okay, congratulations, Garnishee.